Ken Pollock. In the family division, unfortunately, all of our courtrooms only have the JAV system, which is the audiovisual recording. As a practitioner, I preferred having a live court reporter present, so I'm inclined and leaned in favor of court reporters. However, having served in a department that only has JAVs, I also know how to use JAVs and make it efficient and effective for the litigants.
It's my understanding that JAVs is being taken out of the RJC and that a new system's being put in called DAR. So I just, I'm looking out for my own job and my own career and my own cohorts here, so I appreciate your, thank you.
Good morning. I know both of you fairly well, so I'm going to ask you a question, and I'd like each of you to take a chance at answering it. The state of Nevada has recently found that its prohibition against felons exercising a right to vote unless their civil rights have been restored, they found that to be unconstitutional. We have very, very similar provision in the Nevada Constitution. Do you believe that the prohibition against felons exercising their right to vote unless their civil rights have been restored, do you believe that to be constitutional or unconstitutional, and why?
Okay. Well, now we're getting into some political questions and matters that may appear before me as a judge, so I can only talk in terms of the abstract, not specifically. From a philosophical standpoint, I believe when you are convicted of a felony and you are a felon, you lose certain civil rights. Among them is the right to vote. Whether the legislature wants to come to a different rule or not is the purview of the legislature and ultimately the citizens in deciding who their elected representatives are and whether the Constitution needs to be amended to prevent such an act. So as a judge, my oath is to follow the law. I'm going to follow whatever the state law is, my personal opinion notwithstanding.
Susan Scan, I have not studied this statute. When I'm running for a civil seat, that's what I do, so I can't speak to the constitutionality of it because I haven't studied it. And again, what the legislature does with it should express the will of the people. I'm not sure, once you're reinstated, and you have apparently paid your debt to society, and I assume that means that this crime is not something that, it's not a murder or a violent crime or something like that. If you have paid your debt to society, you've been reinstated, then I think the right to vote ought to come back with that. That's just a personal opinion with me, but I think that if you're trying to encourage people to become responsible citizens and that they pay their debt, that means they did pay their debt and you have a chance to be a productive human being again. But that entirely depends on what the felony is and what the statutes say about how you actually accomplish being reinstated. And I would certainly follow the law on that.
Thank you. My name is Travis Brake, and I'm going to give you, both of you, a hypothetical and ask you both to respond. You're sitting on the bench and you receive a motion to quash, and it is on behalf of a veteran in another jurisdiction who is currently receiving treatment through a VA program. Apparently, the VA finds out that this veteran has this foreign felony warrant and alerts the veteran that his entitlement to treatment is going to be terminated unless that warrant is quashed. So at the hearing on the motion to quash the warrant, the VA is screaming that this person needs to be brought back to the jurisdiction to answer for their jumping probation or failure to complete the program. What are you going to do?
Susan Scan, again, we're talking about an area of criminal law with which I'm not intimately familiar, but it seems to me our state has just passed a law that allows non-violent felons to go through a diversionary program. So that indicates a legislative ruling and a public policy that treatment for veterans is important. If it's possible to structure this so that the veteran still has to answer to that felony warrant, because at some point in time he's going to have to appear and have to come back, but to complete the treatment, I think that that's an important public policy that should be followed, because what we wanted, rehabilitation is part of the process, and I think our legislature has indicated that that's something that should be done. So if it's possible to structure it so that the sentence can be, depending on what it is, can be served as a result of or after treatment, or treatment would be completed, I would be trying to do that. But of course, it would be my job to follow the statutory law.
Okay, I guess it's Ken Pollock. For me, the analysis starts with what's the nature of the offense that we are dealing with, that's the underlying offense, and also what's the nature of the violation that they're accused of. Is it a major violation on a major violent crime, or are we talking an insignificant violation or a failure to appear when they were actually in treatment in custody facility, so, or inpatient facility? So you need to know the facts underlying where we're at. I mean, in terms of the hearing, under ADKT 424, the veteran can appear by electronic means so that they are present for the hearing so that you can hear from them. They have the right to counsel, and I would expect, since I have a motion and I don't have a litigant in front of me and I'm actually hearing it, I probably have counsel in front of me so that we can at least address the issues and see what we're dealing with, what the nature of the problem is, and then figure a remedy from there, whether it's going to be quashing and giving a new court date, whether it's going to be enforcing the warrant. It all depends on the facts of that specific case.
Thank you.